Hey, so you have your trust, or at least you're planning on having a trust, and you intend to use it for a specific purpose, whatever it is you want to use it for. Whether you intend to use it to protect yourself, your assets, or to take whatever has been subrogated, whatever has been taken away from you, or whatever you've been compelled to do under the capacity of being inferior. You need to know some basic things. Many people talk about foreign trusts and domestic trusts. You merely naming your trust foreign, private, irrevocable, whatever it is you want to name it, does not make it foreign. It is how you function with it that determine its status. And certain things in certain places are placed specifically to basically let you know, all right, we're in the business of basically taking booties, which is a maritime word for, which is a form of the taking of possession of others, whether it's from some type of feud or some type of voluntary waiver. And a lot of it is within the UCC, but some of it is also codified within the Code of Federal Regulations. Now, the Code of Federal Regulations is specific to the executive departments of the United States and its agencies, and it's meant for them to use. And because it's meant for them to use, it's a regulation that says, all right, this is an instruction book for how you take booties. And if this requirement isn't met, don't touch it. If it is, do so by all means, because, well, this is business. If someone waives it or someone gives it to us, then we take it. And the part of the Code of Federal Regulation that really does a very excellent job at delineating this foundational difference of how they determine whose property to take, whether through the probate process or before then or after it, is within 26 CFR, specifically subsections 301-7701-7. And if you really want more explanation of this, it is codified within the Federal Register. I mean, it's explained within the Federal Register. So the Federal Registrar is the main place where they release these things. The Federal Registrar is the publication medium. It has a volume number and whatnot. So if you're interested in getting certified copies of this would be the reference that you're going to make reference to when it comes to certain aspects that you may want to use as admissible evidence or judicial notice when it comes to administering your trust, or if someone intends to trespass on it, or if you just want to put certain notices out there. Make reference to these and the specific parts of it rather than these. But nonetheless, these gives the general deep explanation of what this is telling you. This gives you the general outline. This explains it in details and what the intent and understanding was when these regulations were published for the use of the executive department and its agencies. So this is how they write in their rule books to take your shit. And you have to understand it in order to protect your shit. So here it is. You merely naming your trust foreign does not make it foreign. You merely saying it's private does not make it private. And the more you keep reading into books regarding equity, the more you realize that these are actually very, very universal principles. And when you start reading texts from, religious books or other spiritual principles that are put in allegories, you start realizing that this is very ancient. And given that fact, in summary, what it basically says is there are two main ways that your trust can be pierced. Meaning, oh, so you want to make a claim using this entity, right? You finally figured a little bit of something out. You now want to come to an entity rather than using someone else's property. Okay, cool. Now we're going to test you. And the two main tests, there are many ways, but the two main tests is the control test and the court test. And all in all, it basically just delineates minimum contact, how you contract. So you can do everything proper with your trust. You can have the divine creator sign in on your paper. If you recontract, which the divine creator and other gods let you know you have the right to do so. If you recontract, other entities will take that which rightfully belongs to you. A trust is a United States person. So before we continue, there are many things in life you want to pass and qualify for. When it comes to this specific section of the Federal Register, you actually don't want to pass it. In this case, you actually want to fail it. I repeat, there are many things in life you want to qualify for and pass. Just like withholdings, you probably don't want to qualify for it. Or maybe you do. Your choice. Depends on how you contract. But when it comes to this specific section, you don't want to qualify for it. You want to fail it. So keep that in mind, because if you pass it, that is how they pierce the trust. That is how you, your business partners, your trust members, and your affairs gets blended right into the partnership, affairs, and activities of the United States. Nothing wrong with the United States. In fact, you can contract with the United States under certain conditions and if you seek certain things. But in other things, you probably should just handle your business and just leave things be. But nonetheless, you don't want to qualify or pass these tests. You don't want to qualify court tests and control tests. And here it is. A trust is a United States person. Meaning it's letting you know if you meet these conditions, we got your ass. The court within the United States is able to exercise primary supervision over the administration of the trust. This is what they call court tests. Meaning if you bring your trust into probate or into a child protective case, because that's really actually probate, because they usually title it in the interest of, and then they name the minors. Or if you are dealing with any supposed criminal case or any other civil case, and you bring your trust, whatever type of trust you have, these are the things that they will not tell you they're doing, and they're not obligated to tell you they're doing. But based on the delineation of the things that you put in and how you approach the whole situation, they will test your ass, and they will just carry on if you qualify for that test, or if the entity that you're bringing in qualify for these tests, the court test and the control test, they will carry on and just railroad you. So keep these in mind when it comes to the operation of law and administrating your trust. A court within the United States is able to exercise primary supervision over the administration of the trust, called the court test. One or more United States person have the authority to control all substantial decisions of the trust. So they're telling you, if you don't delegate someone that is not a United States person to control substantial decisions of the trust, then they got you. If whoever controls substantial decision of your trust is a United States person, you and that trust is a United States person. A property cannot own a property. And by virtue of that, they are able to exercise primary supervision over the administration of the trust. So this first part really makes more sense when you read it like this. A trust is a United States person if one or more of the United States person have the authority to control all substantial decision of the trust, and or therefore a court within the United States is able to exercise primary supervision over the administration of the trust. And they call this court test and control test. Control test is who controls the substantial decision. Court test is when you're in a certain venue. If this is out of place, then automatically they will turn into a constructive trust. Which, when you look at all the different types of court within your state, the probate court, county court, criminal court, municipal court, they all have Supreme Court, whatever it is. At one point or the other, you will see that there's an administrative division within. At Illinois, it's within the Supreme Court. There's an administrative division within the Supreme Court of Illinois that basically manhandles all these other courts. So find the equivalent in your state, and that spot is where they pretty much point fingers and say, all right, this is the one we got and we're going to construct it. And or nope, we don't have power over this. But sometimes it doesn't even get that far, because once you come in right, the acting trustee, the ministerial trustee, or whatever court venue you are publicly, would know better, because they do follow this even on a state level. Because remember, the states are also 14th Amendment citizens, which are a United States person, and their whole goal is to subrogate you and homogenize everything, turn it into theirs so they can just do what they do. It's all business. It's nothing personal. No one has anything against you. It's just what they do. So make sure that whoever has the authority to control your stuff in a trust, the one who controls in the public is a trustee. So your trustee must not be a United States person. Whoever controls substantial decision, make sure you make it very clear that they're not a United States person. Or else, if you're trying to function with it under any circumstance and there's any dispute that you're coming in or that someone brings you into, they will construe it as their property. Then goes on to say, a trust is a United States person for purpose of internal revenue codes. They're automatically merging the taxation aspect, which is the withholding. If you are our property, then you are bound to give us your dues. You're bound to give us our fair share. So if under any circumstance any of these apply, then well, they got the private entity that does their accounting for them. They're going to bring that into the equation. So it's a perfect transition, and they're letting you know. A trust is a United States person for purpose of the Internal Revenue Service, Internal Revenue Code, on any day of the trust, and on any day that the trust meets both the court test and the control test. For purposes of the regulation of this chapter, the domestic trust means the term domestic trust means a trust that is a United States person. The term foreign trust means any trust other than a domestic trust. Meaning whatever a foreign trust is, they cannot stipulate or determine what it is. That is why it's foreign, because they have no power over it. You make what your foreign trust is however you want. So long as you're not trespassing on others, so long as you're acting in good faith, and so long as you fail the court tests and control tests. You want to fail these. You don't want to qualify for it. You want to fail them. B goes on to tell you the term of the trust instrument, an applicable law, must be applied to determine whether the court tests and control tests are met. Remember, you don't want to meet them. This is one of the few things in life you actually want to fail. And then it lets you know the terms of the trust instrument. They're letting you know you should create terms and conditions. Trust law and contract law goes in hand in hand. So always create your terms and conditions of how your trust will be ran. Be very strict with it. but know what you're doing. And part of what you'll be doing is put these two things into consideration: the core test and the control test. And letting you know, you must have terms and conditions to your trust. It says the terms of trust instrument and applicable law. These applicable law usually is whatever type of trust you say you want to come in as. You want to come in as inter vivos. You want to come in as unincorporated association. You want to come in You want to come in as LLC. All these different entities are type of trust. The only difference is with an LLC, you just have to state sharecropping, and every year when you pay that yearly fee for your LLC, well, it's no different than this. You're paying tax, and in this case, you're just doing it to the revenue department in the state rather than a federal level. So if you want to come through any other type of trust, which credit to Jonah Bay, he teaches express trust, which basically allows you to, and within its definition, allows you to basically say whatever you want and do whatever you want with your trust. It's not limited. And when there are things making reference to it, it basically goes back and gives you a good old 360 letting you know you determine it. And also, they are doing the same thing here, letting you know the terms of the trust instrument. You must determine how it's ran. So that speaks for itself. Always express your terms and conditions. It says the terms of the trust instrument and applicable law must be applied to determine whether the core test and the control test are met. Applicable laws are like Uniform Probate Code if you're dealing with a probate property or dispute. Uniform Commercial Code also if you're dealing with security interest or some type of interest in other real properties, etc., etc. Applicable law also means the Constitution or treaties that you make to apply to it, or the terms and conditions. These terms of trust instrument is the same thing as applicable law. You make your own law based on the contract that you stipulate within the trust instrument. So keep that in mind. And then C goes on to say the core test. This is an extremely powerful thing. Safe harbor. A trust satisfies the core test if the trust instrument does not direct the trust to be administered outside the United States. So you want to function privately, they're laying it out to you straight out exactly what you need in order for your trust to in fact be foreign and private. They're letting you know you have to stipulate the laws of the trust, terms and condition that says that this trust is not going to be administered within the United States, meaning its jurisdiction is outside the United States. It's not redundant for you to state those verbiages, and even if you don't state those verbiages, put similar verbiage. Again, a trust satisfies the core test. Remember, you want to fail it. You don't want to pass these things. You want to fail it. You don't want to qualify for these. A trust satisfies the core test if the trust instrument does not direct the trust be administered outside of the United States. Meaning you want to direct the trust to be administered outside of the United States. You want to do the opposite of this. And then it goes on to say the trust satisfies the core test if the trust in fact is administered exclusively in the United States. In terms of conditions to make your trust foreign is to in fact delineate that it is not administered exclusively in the United States. Then it goes on to say the trust satisfies the core test if the trust is not subject to an automatic migration provision. Automatic migration provision is really the main part of safe harbor, meaning at any situation where, like for probate for example, they bring any of the property that the trust has interest in or ownership of, you should delineate certain contract laws that, hey, if you are, say, Say, for instance, you're one of the original inhabitants of North America, and you somehow figured, oh, wait, hold on. According to customary law, this happens when this happens. That happens when this happens, and this is invoked when that is invoked. Or say you're from outside the United States, and you have customary laws based in your culture. You can actually stipulate within your trust that if certain things happen and the property has to be adjudicated or determined, then it will be determined by the customary laws or the customary courts of whatever you really are. And make sure you substantiate it. Don't straddle the fence. Don't fake it, because the quickest way to really get it stuck at you when it comes to stuff like this is when you're faking it. So be true to yourself and really know who you are. That is only when these things are going to work for you. If you were respectfully, if your ancestors came here through Transportation Act of 1717, look into that, because there are applicable laws that benefit you also. Be truthful to yourself, because these guys, they know who's who. And if you begin to want to lie to them and say this is who you are and who you're not, they're going to ignore you and turn the other eye and then stick the fist up your ass. Overall, it gives you the details of what safe harbor is. But when you think about it, this doesn't really give you the bigger picture. So we'll look at the bigger picture through Investopedia. Investopedia is a business website to keep track of certain things and look at definitions. Believe it or not, we all say all crimes are commercial, and I think it's within the 26 CFR also, where it delineates all the different types of activities that are construed as commercial, but it's within the Code of Federal Regulations. So if we know all these courts in the United States are commercial in nature, then know very well that safe harbor, that term safe harbor, is a commercial term, and you must understand it, because this is their instructions of how to subrogate other people's property and make it theirs, and they do it through commerce. So don't run away from it. So what is safe harbor? A safe harbor is a legal provision to sidestep or eliminate legal or regulatory liability. In other words, it's a way to avoid liability in certain situations, provided that certain conditions are met. And those conditions, they give it to you right here. They just tell you, look, just make sure your stuff has its own provisions, and the actual operation of it aligns with that provision, whereby it's not administered inside the United States, meaning you don't sharecrop any of your properties with us, meaning you really do have interest in everything that you say you're doing, and whoever it is controlling a substantial decision does not belong to us. So you did a name change, right? You change your name and you say, well, I changed my name, that's foreign. Which court gave you the court orders to change that name? Is it a court under the jurisdiction of the United States? Then no, that's not a foreign trustee. Then goes on to say, court. The term court includes the federal court, state court, or local court, county courts. When you usually hear the word local courts, they're referring to county courts. It says United States. The term United States is used in this section in a geographical sense. It is letting you know who your foreign trustee is supposed to be. They are giving it to you straight up. Whoever is going to be controlling this substantial decision, in order for you to not qualify for this control test, geographically, it's not domiciled within the United States. Yeah, the United States is based on the Act of 1871 established in Washington, D.C., but there are subsidiaries through 14th Amendment, and those are the state ofs. And the beautiful part about that is the state capitals are usually the limitation of the boundaries during geographical bounds. Then guess what? That state capital, which is the geographical bound of the subsidiary of the United States, have other subsidiaries. And they have their geographical bound. And when you really look at the map, they pretty much got the map covered. So geographical, in a geographical sense, make sure that your trustee who is going to be controlling substantial decision is now within the geographical bounds where the United States is doing business. Granted, other foreign entities can share the same geographical bound with other entities. Thus, for purposes of the court test, the United States include only the states and District of Columbia. State, for purposes of subchapter E and the regulations thereunder, the term state shall include the District of Columbia, but not include the Commonwealth of Puerto Rico or any possessions of the United States. Shall not include the Commonwealth of Puerto Rico. Shall not include possessions of the United States. So what does primary supervision mean? The term primary supervision means that a court has or would have the authority to determine substantially. Substantial is basically the core of what you say that trust is about or not. And they become the daddy and the mommy of your trust. Substantially all issues regarding the administration of the entire trust. They're letting you know. They're being very forthcoming. It goes to say a court may have primary supervision under paragraph C, 3, 4, notwithstanding the fact that another court has jurisdiction over a trustee, beneficiary, or trust property. They don't delineate what another court means, but the presumption here is they're talking about their court, meaning they have subsequent jurisdiction, so long as you qualify for control and court test. Determined administration of the trust means the carrying out of the duties imposed by the terms of the trust instrument. Again, there goes this word trust instrument. You have to create your terms and conditions and applicable law. There he goes again. Common law, contract law, Uniform Probate Act, Uniform Commercial Code. If you allow those to apply. If you allow it to apply. Or any specific law governing any specific type of trust that your function includes. Including maintaining the books and records of the trust, filing tax returns, managing and investing the asset of the trust, defending trusts from suits by creditors. Remember how they use the GSA to subrogate you, and how the GSA is how they attach monetary value to anything, regardless of whether it's civil or criminal. They already make themselves creditors in the back door automatically without you knowing anything about it. And determining the amount and timing of the distribution. You don't want them to do any of these. So make sure you don't qualify for court tests and control tests. Situations that cause a trust to satisfy or fail to satisfy the court test. You want to fail this. I know it sounds very odd. You want to fail the court and control test. You don't want to pass it. You don't want to satisfy it. You don't want to qualify it. You don't want to pass it. You want to fail it. Except as provided in paragraph C42 of this section. Paragraph C4IA through D of this section set forth some specific situations in which a trust satisfies the court test. The fourth situation described are not intended to be an exclusive list. The first one is Uniform Probate Code. This is how you satisfy court test. Remember, you can create instruments of your own trust to determine how to operate it, or how it's going to be operated or administered. Another applicable law, meaning if it applies, cool. If it doesn't, then this supersedes. Now, how do you determine whether these four things apply? Trust instrument. Applicable law, meaning if it applies, if you allow it to. Uniform probate code. Trust me, the court test if the trust is registered by an authorized fiduciary or fiduciaries of the trust in a court within the United States pursuant to a state statute that has provisions substantially similar to Article 7, Trust Administration of the Uniform Probate Code. What is the Uniform Probate Code? Article 7. Each state has a uniform probate code, and Article 7, they're uniform. So similarly, the articles will have similar verbiage and similar concepts and similar principles. And at Illinois, it's basically talking about how wills are, well, first of all, the probate code in Illinois is within Public Act 79328 and other ones that are conjoined when they add to it. This act may be cited as Probate Act of 1975. So Article 7 talks about how foreign wills are admitted into the state. And remember, it's telling you you qualify for the court test if the will is admitted into the state. Meaning, if whenever probate exists, one of your fiduciaries voluntarily bring authenticated copies of it into the court, then they got your ass also. That's another way. So read the equivalence version on your end and study it. But in brief, it says proof of foreign will by copy. A written will admitted to probate outside the state is sufficiently proved to admit it to probate in this state by introducing in evidence an authenticated copy of the will and the probate thereof. So if you willingly bring in your will into this state with the intent of it being administered here, without, because the will basically tells you the terms and conditions, what happens to a property upon someone passing away. So why then would you want to bring another third party to administer it for you? If you don't delineate who gets what and who acts as a middleman within your will and within your trust, which by the way, a will can be put into a trust. So do that rather than have them construct it for you and act as a trustee to determine who gets what and how. So you put that terms and condition. Remember, applicable laws. These other things are substitutes if you fail to create terms of the trust instrument. So if you have a will, put it into a trust and specify exactly who acts as the trustee to distribute these trust units or these trust assets. Otherwise, they will probate it. The moment these come into equation, they're taking your shit. That's what this basically says. And that's how you qualify for court test. Second goes to say testamentary trust. In the case of a trust created pursuant to the terms of a will, probated within the United States, other than an ancillary probate, if all fiduciaries of the trust have been qualified as trustees of the trust by a court within the United States, the trust meets the court test. Again, if the substantial decision is not determined by someone actually foreign to the United States, regardless of your interpretation of what the word foreign means, someone who is truly foreign to it, then they got you again. Inter vivos trust, live in trust. In the case of a trust other than a testamentary trust, if the fiduciaries or beneficiaries take steps with a court with a court within the United States, meaning any of the people and trust members, if they take steps, I mean they voluntarily go into the court within the United States to determine the affairs of their shit without, because the whole purpose of you creating a trust is so that you could handle your affairs without others meddling in it. You don't want to go into probate. You want to avoid it by all means. That's the purpose of you creating a trust. And these inter vivos and testamentary is under the condition of probate. This is the medium that they use to take your stuff. Every court case is really technically a probate court when you really think about it in that sense. Then they let you know the moment any beneficiary or fiduciary takes steps, meaning it's just another very cute word of saying if you voluntarily come into our jurisdiction, that causes the administration of the trust to be subject to the primary supervision of the court, then you meet the control test. Then you meet the court test. Then under any circumstance, if anything that we do within our trust and the judicial aspect of it that we've set up, if you come into our venue, you give us your jurisdiction. You relinquish yours. You give us personal subject matter and territory jurisdiction to arrest whatever property is in dispute. Simple as that. And then the last one. The United States courts and a foreign court are able to exercise primary supervision over the administration of the trust. If both a United States trust and a foreign court are able to exercise primary supervision over the administration of the trust, the trust meets the court test. Then even if you put a safe harbor provision into your terms and conditions of your trust, so long as the United States still has subsequent jurisdiction, they still got you. These are the things you have to put into consideration for your trust to really be private. When that cop pulls someone over on the side of the road, writing the ticket, they're suing you right there. That is the summons that they're serving you. That ticket, they're serving you the summons and the complaint. Right then and there. That is it right there. And how do they enforce that summons and complaint that they've sued you? Like, hey, you broke this administrative law. These courts. These are how these courts, federal, state, and local ones, is how they administer their affairs. And if you start straddling the fence and mixing jurisdictions, they construe it as their shit. Automatic migration provision. This is along the same line of safe harbor now. Notwithstanding any other provision of this section, a court within the United States is not considered to have primary supervision over the administration of the trust if, and these are the conditions for them not to have jurisdiction over it. If the trust instrument provides that United States courts attempt to assert jurisdiction or otherwise supervise the administration of the trust directly or indirectly will cause the trust to migrate from the United States. This right here is state harbor clause, the safe harbor clause. I'm not saying you do this, but you should probably incorporate similar verbiage into the terms and conditions of your trust. But know who you are and what applies to you. Because where are you going to be going? What court are you going to be referring to? Think about that. However, this paragraph C411 will not apply if the trust instrument provides, meaning this is how they can pierce your shit, even if you put that terms and condition there. This paragraph will not apply if the trust instrument provides that the trust will migrate from the United States only in the case of foreign invasion of the United States or widespread confiscation or naturalization of properties in the United States. Well, they're letting you know, in addition to this clause right here, letting you know when the safe harbor is activated, make sure you add this part also. Excluding this part. Add the exclusion of this condition into your terms and conditions. Then it gives you the example. Go read it. It's long-winded. You can do it. And then it goes to control test. So that was the court test. They just basically explain to you how you can protect your stuff by delineating what it's governed by and what conditions and the if-then circumstance involved. And how they step in. They tell it to you. Is there more? Yeah, there's more. And it's within the state laws. And then the control test. United States person. The term United States person means a United States person within the meaning of section 7701A30. For example, a domestic corporation, they give you the example here. For example, a domestic corporation is a United States person. Corporation is a person, a legal person. Regardless of whether an artificial legal person, an ens legis, whatever you want to call it. Regardless of whether its shareholders are United States persons, meaning a natural person who is not a corporate entity and have interest in a domestic corporation. And that natural person who has interest in that domestic corporation can be foreign. Either way, so long as that corporation is deemed domestic by way of it having other United States persons or qualifying for any of these, it is still a United States person. Once again, the term United States person means a United States person within the meaning of section blah 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 blah. And then it just gives you an example. A domestic corporation is a United States person regardless of whether its shareholders are United States persons. Read this section, but nonetheless just know that this is a summary of what this tells. It basically outlines the different types of entities that are United States persons, and even if it's a trust, so long as one of the shareholders is domestic, and if the substantial decision, which links it back to the court test or the control test, which is this right here, if the substantial decision is controlled by someone that's not foreign, it is a United States person. Basically, this first part just basically lets you know, get somebody who's foreign to control the substantial decision. And the second part really just goes into details of what this really is. The term substantial decisions means those decisions that persons, they're corporate persons, legal person, artificial persons, and natural persons. And that's a very broad term they're giving you right here. So just keep those two distinctions in mind. And remember that it's more specific to the administration of another entity. And based on the status of these persons is how the administration is determined. So just keep that specific part in mind. So the term substantial decisions means those decisions that persons are authorized or required to make under the terms of the trust. There goes this, you keep seeing this word, the terms of the trust, the terms of the trust. They're letting you know you can create your own contract. You can create your own laws. This term is the same thing as contract. Contract is law. Contract makes the law. There's a maxim that goes along the same line. The term substantial decision means those decisions that persons are authorized or required to make under the terms of the trust instrument. An applicable law. This word applicable law is always secondary for a good reason, because it's subordinate to what you delineate, and that are not ministerial, such as what they do, meaning substantial. And then it goes on to give you what examples of substantial means. Decisions that are ministerial includes decision regarding details such as bookkeeping, which is what judges do for GSA bond. That's the only reason why they're sitting up there. The collection of rents, which is why they're sitting up there. If not, then they hold you in contempt and throw you and keep holding you as surety. And on a sidebar, when they talk about I'm going to put you in contempt of court, it is good to ask whether it's civil or criminal contempt. But what they're really telling you about is not that you've disrespected the court or that you're acting awry or that you're not being lawful. What they're saying is you've signed a contract that says you're a debtor, but you're standing here acting like a creditor. What's wrong with you? So entertain those principles, and they won't hit you with contempt of court, because they're just collecting rent. That's it. They're acting as landlord. They're acting as your father. Nonetheless, continuing on. And the execution of investment decisions, the GSA bonds that they're administering. And you can do the same thing with your trust. But just know that according to how they determine whether they want to pierce a trust or not, when it comes to things of financial nature, because basically this is what all this is: bookkeeping, collection of rent, execution of investment decisions. That's deemed as ministerial decisions. So you should probably create terms and conditions within your trust that's going to separate who's going to control finance and who's going to control these other things, which is the substantial decisions. And then it goes, so it gives you the definition of what a ministerial decisions are, which is distinct to substantial decision. Substantial decisions include but are not limited, meaning you can determine what the substantial decisions are and make it very clear. Substantial decisions include but are not limited to decisions concerning a whether and when to distribute income or a corpus, meaning a body of something. So this is the management of the amount, collecting it, and executing investment decisions, meaning go do this, go do that. But who distributes the trust certificate units and who distribute certain amounts, or who collapses the trust, is when the corpus, the res, the property that's held in trust, is satisfied, when the intent is complete, then the trust collapses. So that makes this a substantial decision. So distribution of income is financial in nature, but that basically collapses any trust that exists if the limitation of that trust is for the intent of transferring any type of monies. The amount of any distribution, the selection of beneficiaries. So whoever selects the beneficiaries is controlling the substantial decision. Keep that in mind. Whether receipt of I don't know how the fuck to pronounce this word. So income is or principle, whether to terminate the trust, collapse the trust, whether to compromise, arbitrate, or abandon claims of the trust, meaning whatever affects the integrity of the core of the trust. Whether to sue on behalf of the trust or to defend the suit against the trust, because when you start going into this shit right here, you got to be careful to not qualify for the court test. So this is substantial. You can make or break the trust. Whether to remove, add, or replace a trustee. Right there. So anything that makes or breaks the trust is what substantial decision is. Whether to appoint a successor trustee, to succeed a trustee who had died, reassign, or otherwise cease to act as a trustee, even if the power to make such a decision is not accompanied by an unrestricted power, blah 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 blah. Just read it. Please read it. It would help you understand what it means to have a foreign or a private trust. Then it goes control. The term control means having the power by vote or others. You're running your own micronation to make all of the substantial decisions of the trust, with no other person having the power to veto any of the substantial decisions, meaning whatever decision whoever makes a substantial decision makes is final. Nobody can override it, and that's it. To determine whether United States persons have control, it is necessary to consider all persons who have authority to make substantial decisions of the trust. Not only the trust fiduciaries. The fiduciaries has to do it. Money. So keep in mind, in that case, it's probably best for you to just make one man or one woman the one who controls the substantial decision. So whoever controls the status of who controls the substantial decision is what the status and the jurisdiction of your trust leans on. If that is weak, if it breaks, your trust falls. You really want to know how and what makes your trust foreign and quote unquote private. Everyone milks that word so often these days. It basically just has no more significance. But nonetheless, you want to begin to understand the basics of what really makes your trust foreign rather than domestic, really makes it private rather than public, what really puts substance to it. Read this section right here. It tells you. Or else you just be dabbling in something that just makes you feel good, but really has no substance to it. Don't do that.